Okay, shall we talk about formalities? We don't have a huge amount of time, so I might be doing a bit of a quick dive, but what I think is really important is to make sure that you understand the legislative elements, because that can be the hardest part of it. But basically, we know in order to make a contract, we need to have agreement, which is made up of offer and acceptance or consensus. We need consideration, we need intention, and we need certainty. What's important in this topic is understanding that none of those things are a piece of paper. But in certain types of contracts, there will be a requirement that comes out of the legislation that requires a certain type of formality, which usually means a piece of paper, but not always, that needs to be done. So some of them, it comes from the type of contract they are. So if, for example, you buy and sell shares on a stock exchange, there's a level of formality in the sense of a formula in which that you need to follow in order to do that. So there are certain kinds of transactions that are followed in a particular way. When we're talking about land in particular, we always need to have a piece of paper. And in that broad sense, it's pretty much everything to do with land. It's not just the land itself, buying and selling it, but it could be creating an interest in it, using it as a security, creating a right that allows people to walk through it to go to the local park, a lease. So you're not selling the land, you're just granting an interest that allows somebody else to use the property in some way. Also, certain types of transactions will have formalities attached to them. So door-to-door sales, for example, there is a requirement that they are in writing and that you have a certain cooling off period. So again, the legislation has required that they're followed in a particular way. So the kind of consequences depend on the type of contract, where it comes from, and what the reason for the formality is. They're mostly civil penalties in the sense that if you don't have a document, then the court will just not hear that there's evidence of that contract. They just will not enforce the contract. Now notice that it's different from there not being an agreement. There's just not an enforceable agreement. So it's not that there is no agreement, it's just that the court will not enforce it. So it's not, well, actually for other reasons, it's quite difficult to transfer land to somebody without a piece of paper, because the reality is that in order to register that transfer, certain forms are required by the Land Titles Office. So, but at the end of the day, I think Anna would be the last person I could convince to do it, but if Anna and I agreed that I could buy her house from her, and I gave her some money, and I went and lived in the house, and she and I never had a fight about it, well, really, until one of us died, it's really not a problem, is it? Unless, unless she went bankrupt somewhere else and she still has a mortgage on it. I mean, look, at the end of the day, we've still got a contract. I've performed my part, she's performed her part, it's just not registered anywhere. It's still not impossible if I were then to decide to sell it to you. We could do that. You would be really stupid to do that, by the way, but we could do it, and if we're not having a fight, it didn't matter. But as soon as one of us wants to enforce that contract, we couldn't do it because the court wouldn't hear it. Then there are certain things where if you don't do them there will be a fine. So the door-to-door sales example is a good one. That is, that's a requirement that's imposed by the law to keep consumers safe. So if you don't do that, then there will be penalties for not doing so. So initially, sorry, I'm probably going a little bit fast. I'm a little bit out of whack as to what order the slides are in. But so originally, the Statute of Frauds was the name given to some legislation that came out in 1677. So it's relatively old legislation. And by the way, it's not still enforced. Well, it might be in the UK, but that is not the legislation that you will be referring to. You will be referring mostly to section 126 of the Instruments Act. So the Instruments Act is a successor to the Statute of Frauds legislation. But the Statute of Frauds was the original legislation that said certain types of contracts need to be in writing. And subsequently, versions of that legislation have been repeated in different places. And the certain types of contracts included guarantees, contracts made in consideration of marriage, contracts for sale or creation of an interest in land, contracts that would not be performed within the space of a year, and contracts for the sale of goods for a price of £10, I should say. So what do these things all have in common? Other than they're the kinds of things that the Statute of Frauds says you need a piece of paper for. All of them are, believe it or not, with that £10, serious contracts. So the Statute of Frauds was created for the purpose of preventing frauds. So back at a time when contracts were the purview of the wealthy in particular, by claiming that you had a contract, you could fraudulently hold somebody to account, get them caught up in litigation. So the Statute of Frauds says, well, we don't care. If you think you've got a contract, that's up to you, but unless it's in writing, we're not going to hear your dispute about that contract if it covers these kinds of things. So 10 quid doesn't sound like a lot of money, but we're talking about approximately $615,000 in today's money. In fact, it's probably going to be a little bit more than that. I did that calculation most recently last March, and as you know, the Australian dollar to the British pound, which is where we're starting from, has declined since then. So more than $615,000. So they're all serious, big contracts, really. Interestingly enough, if you go through the case book, you will see the legislation or the successors to the Statute of Fraud in each of the Australian states. And pretty much all of those are still enforced in Tasmania. So down to the point where unless you have a written document, and it might have changed more recently because I have not checked it again, but unless you have a written document for a transaction of an amount greater than £20, technically might not be an enforceable, sorry, $20, it might not be an enforceable contract. So again, you can spend some time in the casebook fiddling around and thinking about whether or not Statute of Frauds actually does what it was intended to do. Does it reduce or increase fraud? It kind of has the opposite effect. Unless you actually know what the law says, if you you could fraudulently enter into a contract with somebody and then ultimately argue that it can't be enforced because there's no paper. So you commit a fraud by actually removing the process if somebody didn't know what was going on. The other main reason, in my view, that we have successor legislation of the Statute of Fraud is as a tax collection opportunity. So one of the things that will happen in relation, particularly in relation to transfers of land or creation of interests in land, is the stamp duty officers in each state can collect a tax, and they literally stamp, until quite recently this is, they would stamp the document. So you needed a document to attach a stamp to. These days not so much, but that's technically where it came from. So where do you find these requirements today? This is the relevant provision, section 126. And this is where I wanted to spend a bit of time because it's not language you are familiar with, at a guess. So let's read through it once. An action must not be brought to charge a person upon a special promise to answer for the debt, default or miscarriage of another person, or upon a contract for the sale or other disposition of an interest in land, unless the agreement on which the action is brought or a memorandum or a note of the agreement is in writing, signed by a person to be charged, or by a person lawfully authorised in writing by that person to sign such an agreement, memorandum or note. And number two, by the way, you can do that with the Electronic Transactions Act. Everybody clear? Maybe not. Shall we pull it apart? An action must not be brought. You can't sue someone for a special promise to answer for a debt. You can't sue someone for a guarantee that they've given you, or upon a contract for the sale or other disposition of an interest in land. You can't sue someone for a guarantee that they've given you or in relation to a contract that deals with land unless the agreement on which the action is brought or a memorandum or note of that agreement is in writing. You can't sue someone for a guarantee or in relation to a contract that deals with land unless the guarantee or the arrangement that deals with land is in writing, or there is a memorandum or note of that agreement in writing. And that, the next part, is signed by the person to be charged or by a person lawfully authorised by that person. Shall I go back to the beginning again? I know it gets boring, but I think it makes sense when you do it. You can't sue someone for a guarantee that they've given you or in relation to an agreement that relates to land unless the guarantee or the arrangement that relates to land is in writing, that is signed and has been signed by the person that you want to sue, or there is a memorandum or note of the agreement that has been signed by the person you want to sue, or if the person you want to sue hasn't signed it, a person that they've authorised in writing to sign it has signed it. So, or their agent has signed it. But their agent just can't be anyone. I can't just say, hey, you're my agent, off you go, sign that, and we'll be golden. I actually have to authorise you in writing, okay? So, let's go through this right from the beginning again. You can't sue someone unless, for a guarantee, breach of a guarantee, or a breach of a contract that relates to an interest or creation of an interest in land in some way, unless the guarantee or the agreement in relation to the land is in writing. That writing is signed by you or somebody that is your agent that you've appointed in writing, or that there is a memorandum or note of the agreement which is in writing, signed by the person you want to sue or their duly appointed agent. You had that right from the beginning, didn't you? That was fine. So that ultimately is the statute of fraud requirement. And it does make it even harder that we will refer to as the statute of fraud requirement in a general sense, but when you are writing about it, you need to work out what the requirement is. Now, I had a list at the beginning of other kinds of formalities requirement. This is the one we're going to spend most of our time talking about, but there are other requirements, most of which are not quite as difficult to read as this one, but there are requirements in relation to formalities for particular types of agreements. It's worth noting in the second part of this as well that you can meet these requirements with the electronic transactions. So up until relatively recently, the shorthand of this, I'd probably be trying to turn it into plain English, and I would have been saying, unless you have a piece of paper. 20 years ago for sure, unless you have a piece of paper. We don't need a piece of paper, we need writing. And we need that writing to be signed. Now, the Electronic Transactions Act says that it's still writing if it's bits. It's still writing if it's electronic, and it also deals with electronic signatures. Still, there are plenty of organisations that decide just to be safe, we're going to have a wet signature, as they call it. Including RMIT makes me actually sign my timesheets. It's like, really? I teach this subject and I have to come in to sign a timesheet. Anyway, just me. I'm really having a whinge about RMIT today. Don't get me wrong, I actually really quite like it. So what's an interest in land? Really, really, really broad. So I did cover this slightly before. There's plenty of information in the materials that you have, but It's basically if you're going to deal with land in any way, you want to be able to enforce it, it needs to be in writing. Guarantees, they are a little bit tricky, and this is the second thing that I want to spend some quality time with you about is I want you to be able to differentiate between a guarantee and an indemnity. Now, you kind of have to trust me on this, but there's plenty of opportunities for you to practice research in determining whether I'm right or not. But I'm using the word guarantee here to mean that special promise to, what are the words? Special promise in relation to a debt. A special promise to answer for the debt, default or miscarriage of another person. So that is a guarantee. So what's an indemnity? Have you heard the term indemnity before? You've heard the term indemnity. You're wishing I didn't see you nod right now, aren't you? Do you want to have a go? What's an indemnity, Ken? You have heard the proof. Cool. Okay. So let's go through it. And a guarantee is a promise to pay another person's debt if they fail to do so. So let's set up something here. So Ken, Matt. That was a little bit random, actually. I think I should know more names by now. So Ken, you want to lend some money to Matt. Well, he wants to borrow it from you. And he looks a bit dodgy. You're thinking, before I lend him that money, I want to know that it's going to be okay. Scott over here, he works in real estate. He's clearly loaded. So what you are going to do is you are going to seek a guarantee, a personal guarantee. So you would enter into a separate contract with Scott, where Scott makes you a promise that if Matt doesn't pay the money, that you can sue him. Okay, so you're lending him money. Well, maybe we won't do it. Actually, it's probably better to, for example, point if he just owes you. He might be your tenant. Okay, you're worried he won't pay the rent. And so you've got a guarantee from Scott, so if he doesn't pay the rent, you can go to Scott and sue him for that. Okay, so we all understand what it is. An indemnity is a similar but different thing. An indemnity is a promise to keep another person free from harm or loss. So if we use the same scenario, if instead of getting a guarantee, if you entered into, so Scott, you're worried about Matt being out there and being homeless, and you can't find anybody who's prepared to rent him a place because he's clearly on the dodgy end. And Scott's worried about this. So Scott said, okay, Ken, if you rent the place to Matt, I'll indemnify you if anything goes wrong. I will keep you safe from harm, effectively, is what an indemnity is. It's like a form of insurance. In fact, we call insurance comes out of the idea of indemnifying. So, and it might be, you're indemnifying against any harm that happens as a consequence of of Matt being the tenant. All right, so we understand they're slightly different, but they have the same output. If the primary obligation on a guarantee is unenforceable, then the guarantor will be discharged. Because what Scott is doing in the first example is he is guaranteeing Matt's performance under the lease. And if it turns out he doesn't wear it well, but let's say Matt is 17 years old. 17. I won't explain why, but it turns out he actually doesn't need this apartment. He has somewhere else to live that is perfectly adequate for his station in life. And so he just stops paying. Actually, no, I need it the other way around for this to work when you think about it. Ken, you're 17 years old, and effectively the contract isn't enforceable. Okay, let's just say the contract isn't enforceable, because I'm actually going to confuse you next time when we talk about the ages if I get all of that wrong. So the contract isn't enforceable, right? There's no consideration, there's no intention, there is something there. Because Scott has guaranteed performance under the contract, no contract, no guarantee. Okay? There's no contract for you to guarantee. But if we've got an indemnity, it will remain enforceable, because what Scott has promised under an indemnity is that Ken will be held free from harm, that he will make up any loss that he suffers as a consequence of the arrangement. So even if there's no contract, so you can't sue Matt because there's no enforceable contract and he just skedaddles out of there with all of the benefits. You can turn around to the person who has given you the indemnity. Do we understand? I made that so long-winded, none of you are going to say, no, you don't understand. But if you don't understand, please contact me afterwards. So we have these two quite serious things. One could argue, in fact, that an indemnity is actually taking on an indemnity is a much bigger obligation than taking on a guarantee, because if there is no contract under a guarantee, being a guarantor doesn't cause you any ill will. So why does a guarantee require writing, but an indemnity doesn't? I can't answer that, by the way. I don't know. And I don't get it. But it gives you an opportunity to have a little bit of critical analysis and to think that through. And Saricha, do you know?
No, I just want to ask a question, actually.
Be awesome if you did. That's all right. I'd be very happy to know. Go on.
I just want to ask, so guarantees, for example, in the real life situations, we often hear about them like bank guarantees and those things. Is there a real life example for indemnity that you could probably mind?
Let me circle back to that, okay? Because, again, these words get used a lot, and even just you using bank guarantee is a different thing again from what I've been talking about there. So, just want to, okay, yep, all right. I thought I had something else that I was going to say there. So, most insurance policies are indemnities, a form of indemnity. Usually, directors' guarantees are where you might see this more often, particularly when people are creating, say, a new business and you've got a small company. The way that it often works is a small company, it might only have $100 of paid up capital, and any other cash it has are loans from the shareholders. And so we talked about this last week, that idea that companies are created so that gentlemen can take risks with other gentlemen's money. And so a company itself, we've heard this, all of you would have heard about Phoenix companies or Shell companies or $2 companies. This idea of a company that just has very limited assets, but it's setting out on an adventure to create some sort of new business. So if you've set up a new company, so Harry, you're setting up a new company, you come to lease this room for your premises from me, and I'm like, yep, absolutely, think it's a great idea, love to rent to you, but I'm going to need a director's guarantee. So in other words, I would be looking for you as a director or you as a shareholder to promise that the company will pay its debts, because that way, and you'll learn this language when you do company law, that way I don't have to be concerned that I might have to lift the veil. So the veil between the corporate personality and the shareholder personality. So a bank guarantee, Harry might say, no, I don't want to be personally liable for this. I've got all of these buggers are my shareholders and I don't know what's going to happen with them and I don't know if I can trust them or not. I don't want me to hang out to dry here. So what we're going to do instead is I'll offer you a bank guarantee. So what a bank guarantee usually is, it's a commercial instrument. You go to the bank and you put in a deposit. So depending on how dodgy you are, I might want anywhere between 3 months and 2 years rent that just sits in the bank earning interest that I can draw on if you stop paying the rent, and at the end of the lease that goes back to you. So you might raise that money and put that aside, and that's better than giving this personal guarantee. Again, all these commercial. So we use this term guarantee all the time. The other place that you see guarantee and indemnity a lot, and I'm drawing more from you can tell I'm a transactions lawyer, so this is, I draw from the kind of transactions that I'm involved in. So if I'm buying or selling a business, there will usually be a set of warranties, we used that term earlier today, where the vendor, the seller of the business, will set out a whole heap of warranties about the assets that it has, the cash flow, whether equipment works or not, how many customers they have. You would see similar things too in land contracts, wouldn't you? That, you know, the dishwasher works or it doesn't work, or I never do land, so, you know, that there's, you make a promise that there's nothing that you're aware of that would change the zoning requirements or something like that. There's whatever your promises are. And they are usually backed with a guarantee and indemnity, usually, because you want both, right? You want to be able to make sure that you can enforce it in the appropriate way. So you might say, these are all these warranties. If any of them prove to be untrue, then the vendor guarantees that the amount will be paid and you're indemnified against your loss. And then, you know, well, I'll leave it for M&A for any of you who come about how we work that out. But there are lots of different examples of how that stuff pulls together. Our point for today is if it's going to be a guarantee, it needs to be in writing. So if you gave the indemnity, I'll come back to you in a second, if you gave the indemnity in writing and there's no contract, he can sue you. If you gave a guarantee in writing and there's no contract, he can't get anything. If you gave a guarantee and it's not in writing and the contract's not enforceable, he can't sue you and he wouldn't have been able to. But if it was enforceable and there was no writing, he's actually not able to enforce against you either. So again, too bad, so sad. Lesson of the day, don't rent to Matt. Seems to be.
Would not recommend.
Any questions, concerns, frustrations?
I had a quick one.
Yep.
With the guarantee, what's the consideration like?
That is such a good question. That's what I thought would be on the slide next. And that can be really difficult. It's one of the reasons why guarantees are often in deeds. Because, sometimes it'll be expressed. So in consideration of your agreement to house my good friend Matt, I have agreed to guarantee his performance under the loan. So remember, consideration is the price of the promise. It moves from the promisee to the promisor. So one way is that. The other is it's usually nominal. So you would pay $1 for his consideration. Usually you'd want to put it in a deed for exactly that reason. It makes them really tricky because what's in it for Scott to just take on this obligation, right? Similarly with indemnities. So again, in the example that I used where, Harry, you were my entrepreneur, weren't you? If Harry's trying to set up a business, so we can see that by agreeing to do something for his company, there's some kind of link there, but where we've just got, you know, the fact you're all in the same contract class, I don't want to know how incestuous you get really, but, you know, we can't necessarily see consideration. So, the other part of that section 126 of the Statute of Fraud requirement was this idea of a memorandum or note of agreement. So we can have it in writing, or we can have a memorandum or note. So agreement, the verb, agreement, the noun, a written agreement, or a memorandum or note of the agreement. So when we have, what am I putting in here? When we have a verbal contract, a plaintiff can rely on a memorandum or note of agreement. So if you and I, so Emily and I might agree that she's going to transfer some land to me. We nut it all out verbally, but then we would need to have a memorandum or note of our oral agreement. So our agreement is the oral agreement, but in order to meet the formalities requirement, a memorandum or note would need to be made. Or we could agree, I'm going to buy that land from her, and we'll have a written agreement, and the written agreement will record our agreement. That is it. So the signing of that written document is the thing that creates our agreement. So why does this matter? We've got to think about timing a little bit. So a memorandum or note of agreement is a document that provides evidence that our agreement exists, where the agreement, the noun, is actually evidence of the agreement. It is the thing that created the agreement. So there are a couple of things that come into effect here. One is, do we need to have one memorandum or note, or can we rely on lots of different documents? Actually, let's see what ones I put in here. So actually, I'm just going to pull them all out so we can see what order they are rather than rely on my memory. So kind of questions that come up in the cases are things like, is the document itself sufficient for us to work out who the parties are and what the subject matter is, what the terms are? Can the document that existed before the contract is made satisfy the requirements? Let's actually, spoiler alert here, what do you reckon? If we've got a memorandum or note of agreement, is that made before the agreement or after the agreement? After. It necessarily has, because it's recording an agreement that's been made. So if it's recording in advance, it's clearly not recording an agreement that has been made. Are you limited to one document, or can many of them satisfy the statute? So we talked about this a little bit early on, this idea of joinder of document. So Joinder, where as long as there is a link running through the document so that you can see that they are linked to each other, you can have many documents to pull the whole of the agreement together. Signature. Again, spoiler alert, but signature is not a big deal. Okay, we just need some sort of mark or some sort of understanding that and we call it the authenticated signature fiction. This idea that if you do something that indicates that you are intended to be attached to that document, then you are attached to it. So the fact that the terms come in an email from your email address is enough. And when you think back to how ancient this is, 1677, lots of people who were entering into agreements couldn't read or write. Okay, so it's just a mark. And again, email or electronic formats, you've already seen that the Electronic Transactions Act applies in relation to this. So Pirie and Saunders, let's do a couple of case studies so you can get the feel for this stuff. This is on the screen there, you can see the basic reproduction from the case of the kinds of things that were on a note that the solicitor made. So it's got the names of the parties here, it's identifying the property, it's saying who the tenant is, it's got terms, 5 years plus a 2-year option, it doesn't even say plus, rental, £5.10 shilling a week, commencement on completion of the property. They want a premium of 400 quid in cash. It's going to use it as a bakery shop. Fixtures, they've got going to have the right to remove provided they don't damage anything. No right to transfer the lease without consent. Already I'm adding some words in there for certainty, right? So the question ultimately became, was this a memorandum of the agreement? And the full court said these aren't actually capable of being sufficient as a note or a memorandum. This was a set of notes for instructions, taking instructions to develop a lease. It's quite clear from the evidence in the case that both the appellants and the respondents contemplated the preparation of a formal memorandum of a lease, and it is, at the very least, doubtful whether the testimony of the latter is capable of supporting the conclusion that an oral contract was made. Okay? So again, we're seeing objective tests once again being applied to what was the purpose of making that memorandum or note. It wasn't to record the agreement the parties had already reached. It was there to get instructions to create an agreement that in turn would become their agreement. A memorandum of note needs to, subject to a couple of exceptions, contain all the essential terms. However, if an essential term is missing, and this is stuff we didn't talk about with the essential terms, which is why I thought we'd get to it here, if an essential term is for the benefit of one party, that party can waive it. Okay, so subject to finance, usually for the benefit of the purchaser, that means that the purchaser can just say, well, no, I'll fund it myself. They can waive that provision if they wish. Talked about this. Memorandum note needs to be created before. Joinder of documents we've also talked about. I think we're almost there, actually. Sorry, I'm just going to have a quick look. Yeah, I wanted to talk about deeds. Sorry, I know I went through very quickly there, but I've given you the high points. And there are desk lectures. So deeds are clearly a very formal type of instrument, and I have put together what I think is an exceptionally handy little table here, which tries to point out some of the differences between deeds and agreements. And this one I'm giving you for free. This is the thing that makes you look really, really smart in law firms, because I know for sure that so many people actually forget this one. So has anybody heard of this idea of a limitation of actions idea? What does a limitation of action provision mean?
You can't take action against someone after the expiry of the period.
Absolutely. So that this is one of the things that's often in the newspapers or used to be in the context of child sex abuse cases, that by the time the evidence arose, it had happened too long ago, and so the courts wouldn't hear the actions because it was too far in the past. So this idea of a limitation of action is that there is a period of time that you've got to make a claim. And if you don't make a claim in that time, it's to provide certainty. It's to mean that things just don't drag on forever. And so there's a time by which the statute of limitations is what it's usually called, by which you have to bring an action. If you document something as in relation to a debt in a standard agreement, the standard limitation applies, which is in most states is 7 years. If you do it with a deed, you've got 12 years in Victoria. It ranges, all of them are greater than 7 years, but every state is different. So again, this is something that often, particularly things that are regularly put together into deeds, where they might not need to be, being able to, I've just seen this, I've given this to every single contract student I've ever had, and a number of them have come back to me later and said, I was doing my summer clerkship, and I just, made a little comment that if we did it as a deed, that was going to be the consequence, and the partner said, no. And it turned out to be true. Do check it just in case it changes, because you've got a little while. But I'm telling you, that's happened a number of times. So, but they are different in a couple of really important ways, and it is worth actually being aware of that. So what happens if you don't comply with the formalities requirements? We've got 7 minutes, and I know some of you might need to get out earlier, so just get out if you need to. The Statute of Fraud and the successor provisions don't make contracts void. I think I've made that point a number of times. You still have a contract. The writing for these kind of contracts are not formation elements. They just go to the question of enforceability. So the contract itself might be unenforceable, but certain dealings between the parties can still give rise to enforceable rights. I'm sorry, the colour choice on that slide is awful. Makes it hard to read. I'm sorry, particularly for colourblind among us. So, reliance. Sometimes you can bring an action in reliance that you have spent money, done something in reliance on a promise that it turned out was unenforceable. So there might be an action in equity there. Specific performance, particularly where there's been part performance. So the contract is unenforceable because of the formality requirement, but a party in good faith has done their thing, they have part performed, it is more likely that equity, so this is an equitable remedy, will require specific performance even though there is no contract from an enforceability point of view. We've got constructive trust or equitable estoppel, again equitable remedies. Restitution, which is something you will deal with in advance, where benefits that one party has conferred on the other will be under an unenforceable contract, can be the subject of a restitution claim. So bringing the parties back to the position that they would have been if they hadn't actually spent that money or done that thing. And then the one that's probably most relevant for this subject is severance. So is all of the contract required to be subject to a formality or only part of it? So for example, I'm selling you my farm. My farm includes my land and it includes a whole lot of equipment. We don't put it in writing. It might be that we can sever out the obligation to transfer the land because it's not in writing, but you can still enforce the promise that I made to transfer the equipment to you because they're separate things and there's no requirement, well, unless probably registration of vehicles or something is a requirement for writing, but not so much for your average shovel. Now, I'm not going to do doctrine of past performance in particular. It's not of huge amount of relevance to you for anything we need to do. It's just sometimes interesting, particularly for equity geeks. So have a look, ask me questions if you have them, but I think we're at the end of our day. So thank you. I'll see you next week and I will see some of you at the Tute on Sunday night. Thank you.